The letter arrived on a Tuesday. I remember because I had just come in from checking the east fence line. I set my gloves on the porch rail and opened the envelope right there. It was from a company called Crestline Mineral Holdings, LLC. The letter was 2 pages long. It had legal language I had to read 3 times. But the core of it was simple. They said they held mineral rights to my land. They said a lease granted those rights. And they said they intended to begin exploratory drilling within 90 days. My name is Ray Elkins. I own 480 acres in Garfield County, Oklahoma. My grandfather bought that land in 1951. My father worked it. I have worked it for 31 years. I know every corner of it. I know where the soil goes soft near the creek. I know which pastures flood in April. I know the land. What I did not know until that Tuesday was that someone had been quietly building a paper claim to what was underneath it. I did not call a lawyer that day. I did not panic. I went inside, made coffee, and pulled out the metal box where I keep every document connected to that land. Deed, tax records, survey maps. And at the bottom, in a manila folder, my father had labelled in his own handwriting, the original mineral lease. I found the expiration date on page 3. That was the beginning of the end for Crestline Mineral Holdings. I want to tell you about the land before I tell you about the fight. Because if you don't understand what 480 acres means to a family like mine, the rest of this story won't make sense. My grandfather, Luther Elkins, bought this land for $1,100. That was everything he had. He drove fence posts by hand. He built the first barn with lumber he milled himself from trees on the property. He didn't have electricity out here until 1958. He didn't complain about that. He just worked. My father grew up on this land. He raised cattle. He grew winter wheat on the north fields. He kept the mineral lease in that metal box because his father told him to. He didn't think much about it. Nobody had ever come knocking. When my father passed, the land came to me. I was 34 years old. I had worked alongside him since I was old enough to hold a fence stretcher. The transition was not complicated. The land was mine. The deed was clear. The taxes were current. I run about 180 head of cattle now. I lease the north fields to a neighbouring farmer for wheat. I maintain the fences, the water lines, the equipment. It is not a glamorous life, but it is mine. It has always been mine. The surface of the land anyway. That last part, the mineral rights, that is where the story gets complicated. And that is where Crestline thought they had me. They were wrong, but I didn't know exactly how wrong they were until I sat down with that old folder and started reading carefully. The lease in that folder was dated March 14th, 1987. It was between my father, Gerald Elkins, and a company called Panhandle Extraction Company. The terms were straightforward. Panhandle had the right to explore and extract minerals from the property for a period of 20 years. In exchange, my father received a one-time payment and a royalty agreement. 20 years from 1987 is 2007. That lease expired 19 years before Crestline ever sent me that letter. I read it again to make sure. I checked the termination clause. It was plain language. No automatic renewal. No extension provision. The lease ended on March 14, 2007, and if no new agreement was signed before that date, all mineral rights reverted fully to the surface owner. My father never signed a new agreement. I never signed anything. There was nothing in that box dated after 2007 connected to mineral rights. So where did Crestline get the idea they had a valid claim? I didn't know yet, but I wrote down every date and every clause from that original lease before I did anything else. I made a copy on my printer. I put the original back in the box and the copy in a separate folder. Then I called my county assessor's office. I asked if there were any mineral rights filings on my property. The woman on the phone was helpful. She said she would check. She came back after a few minutes and told me that yes, there was a recorded document. It had been filed 8 months earlier by a company called Crestline Mineral Holdings, LLC. It referenced a lease assignment chain going back to Panhandle Extraction Company. I asked her to mail me a copy. She did. When it arrived 3 days later, I read it carefully. Crestline was claiming they had acquired the mineral rights through a series of company sales and lease assignments. Panhandle had sold assets to a company called Mid-States Resource Group in 2003. Mid-States had sold to another company in 2009. That company had eventually folded into Crestline. The problem with all of that was simple. You cannot assign a lease that no longer exists. Panhandle's rights expired in 2007. Whatever they sold to Mid-States in 2003 was a lease with 4 years left on it. When that lease expired in 2007, it was gone. There was nothing left to pass forward. Mid-states couldn't sell what they didn't have. Neither could anyone after them. Kreslin had paid money for a dead document. I didn't feel sorry for them. I felt something closer to calm. The kind of calm you feel when a problem that looked complicated turns out to have a very clean answer. But I also knew that a clean answer on paper does not stop a corporation from pushing forward. I was going to need more than a folder and a clear head. 2 weeks after I received that county document, a truck showed up on my property. It came down the main drive without calling ahead, without asking. It was a white pickup with a Kreslin logo on the door. 2 men got out. One was carrying a clipboard. The other had what looked like survey equipment in the truck bed. I walked out to meet them. The man with the clipboard introduced himself as a field representative. He said his name was Todd. He was polite enough at first. He told me they were there to do a preliminary survey of the land. He said it was standard procedure before exploratory drilling began. I told him to stop right there. I told him this was private property. I told him no one had my permission to survey anything. I told him the lease they were relying on had expired in 2007 and that they had no legal right to be on my land. Todd looked at me like I had said something foolish. He smiled. Not a friendly smile. The kind of smile that tells you the other person thinks you don't understand your own situation. He said the mineral rights were a matter of recorded title. He said their legal team had reviewed everything. He said I was welcome to speak with their attorneys if I had concerns. I said I would be doing exactly that. Then I told both of them to get back in their truck and leave my property. I told them clearly and without raising my voice. I told them that if they touched a single survey stake into my ground before this was resolved in court, I would treat it as trespassing. Todd wrote something on his clipboard. He thanked me for my time. They got back in the truck and left. I watched the truck until it turned off my drive onto the county road. Then I went inside and wrote down everything. The date, the time, their names as best I could remember, the truck's license plate number, which I had memorized while they were talking. What was said, what was implied. I wrote it all in a plain notebook that I kept on the kitchen table from that day forward. That notebook became one of the most important documents in this entire case. Because what Todd did not tell me that day was that Kreslin had already scheduled a drilling contractor. They had already filed a notice of intent with the Oklahoma Corporation Commission. They were not coming to ask. They were coming to measure. They expected to be back with equipment within 60 days. I found that out later. But right then, standing in my kitchen writing in that notebook, I knew one thing clearly. This was not going to be a phone call. This was not going to be a letter. This was going to be a fight. And I needed to be ready before they made their next move. I found my attorney through a neighbor. His name was a man 2 farms over named Bert Cassin. Bert had dealt with an easement dispute 4 years earlier and come out of it clean. He gave me a name, Dale Whitmore, a land and mineral rights attorney out of Enid. I called Dale the next morning. He asked me to bring everything I had. I drove to his office that Friday with the metal box, the copied lease, the county filing from Kreslin, their original letter, and my notebook. I laid it all on his desk. He read quietly for about 20 minutes. I sat across from him and said nothing. I have learned that lawyers think better when you let them read. When he looked up, he asked me one question first. He asked if I had ever signed anything related to mineral rights after 2007. Any document. Any renewal. Anything with my signature on it. I told him no. He nodded slowly. Then he walked me through what he was seeing. The original Panhandle lease was clean. 20-year term. No renewal clause. Expiration date was unambiguous. The assignment chain Kreslin was relying on had a fundamental problem. Panhandle could only assign what they legally held. After March 2007, they held nothing. Every transfer after that date was built on an expired foundation. Dale called it a void chain of title. He said it in plain terms. He said, imagine you sell someone a car, but the title to that car expired before you sold it. Every person who bought and sold that car after the expiration is trading a piece of paper that means nothing. The car, or in this case the mineral rights, never legally moved. I understood that. What Dale wanted to know next was why Kreslin had filed with the Oklahoma Corporation Commission. That filing was a problem. It meant they were treating their claim as active and valid. They had put it on the official record. Even if the underlying lease was dead, that filing gave them a legal foothold to push forward unless someone challenged it directly. He said we needed to file a quiet title action. I asked him what that meant in plain terms. He said it is a lawsuit that asks a court to look at all competing claims on a piece of property and declare who actually owns what. Once a court rules in a quiet title case, the record is clear. No more competing filings. No more grey area. I asked how long it would take. He said it depended on whether Crestline fought it or folded. If they folded, weeks. If they fought, months. I told him I expected them to fight. He agreed. Then he told me the filing fee and his retainer. I wrote the check that afternoon. On the drive home, I felt something settle in my chest. Not relief, exactly. More like the feeling you get when a long job finally has a clear starting point. Dale filed the quiet title action 11 days later. Crestline had 30 days to respond. They responded in 18. Their answer was 42 pages long. I know because Dale called me and told me, and I could hear something in his voice that was almost amusement. He said they had sent a team, not one attorney. A team. The lead attorney was from a firm in Oklahoma City. Large firm, the kind with a floor of a downtown building and a name with 4 last names in it. Their response did not concede a single point. It argued that the lease assignment chain was valid. It argued that Panhandle's rights had been properly transferred before expiration. It argued that my father had been notified of the transfer and had not objected. That last part stopped me. I called Dale and asked about it. He read me the specific language. Crestline was claiming that in 2003, when Panhandle sold assets to Mid-States, my father had received written notice and had not responded within the objection window. They were treating his silence as consent. I asked Dale if that was a valid legal argument. He said it depended entirely on whether proper notice had actually been sent and received, and whether the notice met the requirements of the original lease agreement. I drove home that evening and opened the metal box again. I read the original lease one more time, specifically the assignment clause. It said that in the event of any transfer of rights, the surface owner must receive written notice by certified mail with return receipt, and the surface owner had 30 days to review and raise objections. Certified mail. Return receipt. I knew my father. He kept everything. Every bill, every receipt, every piece of correspondence related to that land. The metal box was proof of that. If a certified letter had arrived about a lease assignment, there would be a record of it somewhere. I spent that entire evening going through the box, piece by piece. I found utility bills from 1,994. I found a survey report from 1,989. I found cancelled checks going back 20 years. I did not find a single certified mail receipt from 2003. Not from Panhandle, not from Mid-States, not from anyone related to a mineral rights transfer. I called Dale the next morning and told him. He said that was exactly what he needed to hear. He said we were going to request full documentation from Crestline, proof of notice, the certified mail tracking number, the return receipt, the delivery confirmation, everything. If they had it, we would deal with it. If they didn't have it, their entire consent argument collapsed. I already knew they didn't have it, because my father would never have stayed silent about something like that. He was not a man who ignored papers related to his land. If that letter had arrived, he would have responded, and if he had responded, that response would be in the box. The box told me everything I needed to know. Dale sent the discovery request to Crestline's attorneys on a Thursday. Discovery is the legal process where both sides have to hand over documents. You cannot hide things in discovery. You cannot say the documents are private. If a court orders you to produce something, you produce it. That is the rule. We ask for specific things. The certified mail receipt proving notice was sent to my father in 2003. The tracking number. The return receipt card showing someone at our address had signed for it. Any internal records from Panhandle showing the notification was completed. Any correspondence between Panhandle and my father from that period. Crestline had 30 days to respond. They took all 30. When their response came, Dale called me and read it to me over the phone. They had produced a lot of documents. The asset sale agreement between Panhandle and Mid-States, internal memos, financial records, transfer paperwork. What they had not produced was a certified mail receipt. What they had not produced was a return receipt card. What they had not produced was any delivery confirmation showing that my father had ever been notified. Instead, they submitted one document. It was a letter on Panhandle letterhead dated August 2003. It was addressed to Gerald Elkins at our property address. It described the asset transfer to Mid-States and stated that the mineral lease would transfer accordingly. It was a regular letter, not certified. No tracking. No signature required. Dale explained what that meant. The original lease required certified mail with return receipt. A regular letter did not meet that requirement. Even if Panhandle had actually sent it, which we could not verify. It did not satisfy the contractual notification standard. The consent argument was built on a notification method that violated the terms of the lease itself. I asked Dale how significant that was. He paused for a moment. Then he said it was very significant. He said Crestline's entire secondary argument had just lost its foundation, but he also warned me not to celebrate yet. He said Crestline would pivot. Large companies with large legal teams do not give up when one argument fails. They find another angle. They push harder. They try to make the litigation expensive enough that the other side gives up. He said to expect their next move to be pressure rather than law. He was right. 10 days later, I received a second letter from Crestline. This one was not from their attorneys. It was from their vice president of land acquisitions. His name was printed at the top in bold. The letter was written in a friendly tone. It said Crestline understood there was a dispute. It said they valued good relationships with landowners. It said they would like to offer me a new lease agreement at favorable terms. They named a signing bonus. It was a large number. I read the number twice. Then I put the letter in my documentation folder and called Dale. Dale told me not to respond to the letter. Not a single word. Not a phone call. Not an email. He said any response I gave, even a polite refusal, could be used to imply I was open to negotiation. And negotiation implied I accepted that there was something to negotiate about. There wasn't. The mineral rights had reverted to me in 2007. They were mine, fully and completely. Negotiating a new lease would mean starting from scratch on terms that should never have been in question. It would also mean dropping the quiet title action. That was exactly what Crestline wanted. I did not respond to the letter. 2 weeks passed. Then their VP called my cell phone directly. I do not know how he got the number. His name was Marcus Hale. He was smooth on the phone, calm and professional. He said he just wanted to have a conversation. He said the legal process was expensive for everyone and that there was a simpler path forward. I told him my attorney was handling all communication related to this matter. I told him to contact Dale Whitmore's office. Then I hung up. I wrote the call in my notebook. Date, time, his name, what he said, what I said. That notebook now had 14 entries. The next thing Crestline did was send a geologist to the county assessor's office. He pulled every public record related to my property. Survey maps, historical drilling records in the area, soil composition reports. They were building a case that the mineral deposit beneath my land was valuable enough to justify a long legal fight. Dale found out about this through a contact at the assessor's office. He told me it meant Crestline was not going to fold. They had done enough analysis to believe there was something worth extracting under my land. That made the stakes higher for them. It also meant they were going to keep pushing. Around this same time, I started keeping a second folder. The first folder had all the legal documents. The second folder had everything else. The letter from Marcus Hale, the notes from the phone call, the names of the 2 men who had shown up with survey equipment, Todd's clipboard, the truck plate number. I also requested a copy of the Corporation Commission filing Crestline had made. I read it carefully. It listed my property by section, township and range. It described the mineral formation they were targeting. It named Crestline as the rights holder. Every word of that filing was based on a dead lease. I made 3 copies of it. One for Dale. One for my folder. One that I put in the metal box alongside the original lease. My father had kept that lease for 30 years without knowing he would ever need it. Now it was the center of everything. I thought about him sometimes during those weeks. He was a careful man. A quiet man. He did not trust easily. But he kept good records because he believed that paper told the truth when people wouldn't. He was right about that. Dale filed a motion for summary judgment in the 8th week of the case. Summary judgment means you ask the court to decide the case without a full trial. You are saying the facts are clear enough that no jury is needed. The law points in one direction and one direction only. Dale argued 3 things in that motion. First, the original Panhandle lease expired on March 14, 2007. The expiration language was unambiguous. No renewal clause existed. No extension had been signed. Second, the assignment notification in 2003 did not meet the contractual requirement of certified mail with return receipt. Therefore, the assignment was procedurally defective under the terms of the lease itself. Third, because the lease expired before any valid assignment could be completed, Crestline held no enforceable mineral rights. Their Corporation Commission filing was based on a void chain of title and should be vacated. It was a clean motion. 3 points, each one supported by the documents already in evidence. Crestline's response came 3 weeks later. It was longer than their original answer. Their attorneys argued that the expiration clause was subject to interpretation. They argued that industry custom allowed for implied renewal when extraction activity was anticipated. They argued that my father's silence in 2003 constituted implied consent, regardless of the notification method. Implied renewal. Implied consent. Two arguments built entirely on implication rather than language. Dale called me after he read their response. He said something I wrote down in my notebook because it struck me as exactly right. He said that when a corporation has no legal ground to stand on, they build a flaw out of the word implied. Because implied means they don't have to show you a document. They just have to make an argument sound reasonable to the right person. Our job was to make sure the right person could see through it. That right person was Judge Carol Nesmith of the Garfield County District Court. She was assigned to our case in the 4th week. Dale knew of her. He said she had handled mineral rights disputes before. He said she was methodical and she did not appreciate creative legal interpretation when plain contract language existed. I took that as a good sign. The hearing on the summary judgment motion was scheduled for 6 weeks out. In the meantime, Crestline did not stay quiet. Their attorneys filed 2 additional motions. One challenged the scope of our discovery request. One asked the court to delay the summary judgment hearing pending further fact-finding. Both felt like delay tactics to me. Dale said they were. He said Crestline was hoping that a longer timeline would wear me down financially or emotionally. He said this was standard practice for large companies in land disputes. They had more resources. They could absorb legal costs longer than most landowners could. I asked Dale directly if I was at risk of running out of runway before the hearing. He was quiet for a moment. Then he said we needed to stay focused and not let them pull us into side battles over procedural motions. He said the summary judgment hearing was the main event. Everything else was noise. I told him I understood noise. I had been farming long enough to know the difference between a problem and a distraction. Judge Nesmith denied both of Crestline's motions in the same order. The discovery challenge was dismissed. The delay request was denied. The summary judgment hearing stayed on schedule. Dale called me with the news on a Wednesday afternoon. He did not celebrate. He just said the judge was not interested in procedural games and that we needed to be fully prepared for the hearing. I appreciated that about Dale. He never oversold anything. The 6 weeks before the hearing were the most active period of the entire case. Dale and I met 3 times in his office. We went through every document in sequence. We built a clear timeline. March 1987, lease signed. March 2007, lease expired. August 2003, defective assignment notice sent by regular mail. 2009, Mid-States transfers to next company. Eventually, Crestline acquires the chain. Every step after March 2007 was built on nothing. Dale prepared an exhibit binder for the court. The original lease was Exhibit A. The expiration clause was highlighted. The assignment notification requirement was highlighted. The letter Panhandle had sent by regular mail was Exhibit B. The absence of any certified mail receipt was documented with an affidavit from Dale stating that despite full discovery, no such receipt had been produced. That affidavit was important. It was not just me saying the letter was never received. It was a legal officer of the court stating that Crestline had been given every opportunity to produce proof of proper notification and had failed to do so. Crestline prepared their own exhibit binder. Dale got a copy through the normal exchange process. He brought it to our last meeting before the hearing and we went through it together. Their exhibits were not strong. They had the asset sale agreement from 2003. They had internal Panhandle memos referencing the notification letter. They had a declaration from a former Panhandle employee stating that it was company practice to notify landowners of assignments. Company practice. Not proof. Not a receipt. Not a signature. Dale circled that declaration and wrote one word next to it in the margin. Insufficient. I asked him about the implied renewal argument. I wanted to understand how they were going to present it. He said their expert witness was a petroleum industry consultant who would testify that in common industry practice, a lease with active mineral potential is understood to carry forward even after a technical expiration date if no formal termination notice was issued by either party. I asked if that was a real legal standard. Dale said it was not a legal standard. It was an industry custom argument. An industry custom does not override plain contract language. Not in Oklahoma. Not in any state he was aware of. I asked him how confident he was. He leaned back in his chair and looked at me for a moment. He said the contract language was clear. The facts were documented. The only thing that could go against us was if the judge decided to give significant weight to industry custom over written terms. He said that was unlikely given the specific language in our lease, but he wanted me to understand that courtrooms were not always predictable. I told him I understood. I drove home that evening and sat on the porch until it got dark. The land was quiet. The cattle were settled. The north fields were showing early green from the winter wheat the neighbouring farmer had planted. Everything looked exactly as it always had. I intended to keep it that way. 3 days before the hearing, Crestline made their last attempt to settle. This time it was not a letter from a VP. This time Dale received a call directly from their lead attorney, a man named Preston Gage. Dale told me about it that same evening. Preston Gage had offered a revised lease agreement. The signing bonus was larger than the first offer, significantly larger. There was also a royalty structure that Dale described as above average for the region, and there was one additional term that had not been in the first offer. Crestline would drop all legal claims and vacate their corporation commission filing entirely. Clean slate, no contested title on record. In exchange, I would sign a fresh 15-year mineral lease giving them extraction rights. Dale laid it out plainly. He said it was a real offer. He said the money was not insignificant. He said I should think about it carefully before the hearing, because once we walked into that courtroom, the offer would likely disappear. I asked him what he thought I should do. He said that was not his call to make. He said legally our position was strong. He said if the judge ruled in our favour on summary judgment, we would win everything and owe Crestline nothing. But he also said that courts were not guarantees. I was quiet for a moment. Then I asked him one question. I asked if signing that lease would mean acknowledging that Crestline had some legitimate claim to begin with. Dale said yes. Any signed lease implied a starting point of negotiation. It would not be an explicit admission, but it would be a practical one. I told him no. I told him the mineral rights under that land reverted to my family in 2007. They were mine without condition. Signing a lease would mean renting out something I already owned outright. And it would mean that the next company after Crestline, and the one after that, would see a signed agreement in the record and think there was something to negotiate. I was not going to create that problem for whoever came after me on this land. Dale said he understood. He called Preston Gage back that evening and declined the offer. The following day, Crestline filed one final motion. It was a request to introduce a new piece of evidence at the hearing, a second declaration from a different former Panhandle employee. This one claimed to have personally prepared the 2003 notification letter and mailed it. Dale objected immediately. The deadline for evidence submission had passed. The declaration was late and the witness had not been disclosed during discovery. Judge Nesmith ruled on the motion the morning of the hearing. She denied it. Late evidence from an undisclosed witness was not coming in. The record was closed. We would proceed with what had already been submitted. I met Dale outside the courthouse at 8:30 that morning. It was a cool day, clear sky, the kind of morning that feels like it means something. Dale shook my hand and said we were ready. I believed him. The courtroom was small by city standards. Garfield County Courthouse was built in the 1930 seconds. Wood benches, high ceilings, the kind of room that feels serious without trying to. I had never been inside it before that morning. Crestline had 4 people at their table, Preston Gage and another attorney I did not recognize, a paralegal with 2 binders, and a man in a grey suit who I assumed was their petroleum consultant. Dale and I sat at the other table, just the 2 of us. Judge Nesmith came in at 9 o'clock exactly. She was a compact woman in her late 50s. She sat down, reviewed something on her bench, and looked up at both tables without expression. She said she had read all submissions carefully. She said she intended to hear arguments on 3 specific questions: the expiration of the original lease, the validity of the 2003 assignment notification, and the implied renewal doctrine as applied to Oklahoma mineral law. Preston Gage went first. He was a polished speaker, confident. He moved through his argument smoothly. He acknowledged that the lease contained an expiration date. He argued that the expiration clause had to be read in context of the broader relationship between the parties. He said that when Panhandle notified my father in 2003, the intent was clearly to maintain continuity of the mineral interest. He said my father's silence was consistent with acceptance. He spent considerable time on the implied renewal argument. He cited 2 cases from other states. He referenced industry practice. His petroleum consultant sat ready to testify about standard operating procedures in the extraction industry. Judge Nesmith listened without interrupting. When Gage finished, she turned to Dale. Dale stood up and spoke for 11 minutes. I timed it. He did not raise his voice once. He did not use complicated language. He pointed to 3 things and 3 things only. He held up the original lease. He read the expiration clause aloud word for word. He said the language required no interpretation. The lease ended on a specific date. No renewal clause existed. No extension was signed. He then addressed the notification argument. He said the lease itself defined how assignment notice must be delivered. Certified mail with return receipt. He said that standard was not met. He said Kreslin had been given full opportunity in discovery to produce proof of proper notification and had produced none. Finally, he addressed implied renewal. He cited 2 Oklahoma Supreme Court decisions. Both held that plain contract language governed over industry custom when the contract terms were unambiguous. He said the lease was unambiguous. Implied renewal had no legal foothold. Then he sat down. Judge Nesmith was quiet for a moment. She looked at her notes. She asked Preston Gage one question. She asked him to point to the specific language in the lease that permitted implied renewal. Gage stood. He referenced the broader context of the agreement. He referenced industry norms. He referenced the 2 out-of-state cases he had cited earlier. Judge Nesmith looked at him steadily. She asked again. Specific language. In the lease. Gage had no answer. Judge Nesmith did not rule from the bench that day. She said she would issue a written order within 30 days. She thanked both parties for their submissions and left the courtroom at 10:47 in the morning. The whole hearing had lasted less than 2 hours. Outside on the courthouse steps, Dale and I stood in the cool air for a few minutes. I asked him how he thought it went. He said he thought it went well. He said the judge's question to Gage at the end was telling. When a judge asks you to show her the specific language and you cannot point to it, that is not a good sign for your case. I drove home and went back to work. I want to say that I spent those 30 days anxious and distracted, but that would not be true. I had done everything I could do. The documents were clear. The argument was clean. Whatever the judge decided, she would decide based on what was in front of her. Worrying about it would not change a single word of her order. So I fixed fence in the south pasture. I checked on the cattle. I had a long conversation with the neighboring farmer about the wheat lease for next season. I called my daughter in Tulsa twice a week the way I always did. The land kept moving forward the way land does. On the 26th day, Dale called me. He said the order had arrived. I pulled over on the county road. I was in my truck coming back from the feed store. I put it in park and sat there with the engine running. Dale read it to me. Judge Nesmith had granted summary judgment in my favor on all 3 points. On the expiration question, she found the lease language unambiguous. The term was fixed. No renewal provision existed. The lease ended on March 14, 2007. On the notification question, she found that Kreslin had failed to produce any evidence that the contractually required certified mail notification had been completed. The regular letter submitted as evidence did not satisfy the lease requirement. The assignment was therefore procedurally defective. On the implied renewal doctrine, she cited both Oklahoma Supreme Court cases Dale had referenced. She wrote that where contract language is clear and specific, implied terms derived from industry custom do not override the written agreement. She said this principle was well established in Oklahoma property law, and she saw no reason to depart from it. She ordered Crestline's Corporation Commission filing vacated. She ordered the void chain of title removed from the county property record. She declared that full mineral rights to my 480 acres had reverted to the surface owner on March 14, 2007, and had remained with the surface owner continuously since that date. Dale stopped reading. I sat in my truck on the side of that county road for a long moment. Outside the window, the fields ran flat to the horizon the way they always had. Same sky, same soil, same land my grandfather had paid $1,100 for in 1951. I told Dale thank you. He said I had done the hard work by keeping those documents. He said most people would have thrown that old folder away years ago. I told him my father kept everything. Crestline had 30 days to appeal the order. Dale told me to expect it. He said a company that had invested legal fees at that level rarely walked away from a first ruling without at least exploring an appeal. He said we should not consider the case fully closed until that window passed. I marked the date on my calendar. On the 19th day, their appeal arrived. It was filed with the Oklahoma Court of Civil Appeals. Their grounds were narrow. They were not challenging the expiration finding. They were not challenging the notification finding. They had apparently decided those 2 points were lost. They were challenging the implied renewal ruling only. Dale called it a Hail Mary. He said they were hoping to find an appeals court judge who would give more weight to industry custom arguments than Judge Nesmith had. He said it was not an impossible outcome, but it was unlikely given how clearly the Oklahoma Supreme Court precedent had been stated in her order. We filed our response 4 weeks later. Dale kept it simple. He restated the 2 Oklahoma Supreme Court cases. He restated the plain lease language. He noted that Cresline was asking an appeals court to override specific contract terms using industry custom, and that this approach had been consistently rejected in Oklahoma property law for decades. The appeals court took 11 weeks to rule. I was replacing a waterline on the east side of the property when Dale called with the result. I had mud on my boots and a pipe wrench in my hand. The appeal was denied. The court found no reversible error in Judge Nesmith's ruling. The implied renewal doctrine did not apply where lease terms were unambiguous. Cresline's argument had no basis in Oklahoma law. The original order stood in full. I set the pipe wrench down on the ground and stood there for a moment. That was it. It was over. The Corporation Commission filing was vacated. The void chain of title was cleared from the county record. My mineral rights were confirmed. Fully. Completely. Without condition. Cresline sent no further letters. Marcus Hale did not call again. Preston Gage did not file anything else. They were done. Dale sent me a final invoice 2 weeks after the appeals ruling. I paid it the same day it arrived. It was the most straightforward check I had written in 2 years. I asked Dale if cases like this were common. He said mineral rights disputes were not uncommon in Oklahoma. He said what made this one clean was the documentation. He said he had handled cases where landowners had the right instinct but could not prove their position because the paper trail was incomplete or missing entirely. He said my father's metal box had won the case before we ever walked into a courtroom. I thought about that for a long time after we hung up. A metal box. A manila folder. An expiration date on page 3 of a lease signed 36 years before any of this happened. My grandfather could not have known what was under that land. My father could not have known a corporation would one day build a legal claim on an expired document. Neither of them kept those papers because they expected a fight. They kept them because that is what careful people do. The weeks after the appeals ruling were quieter than I expected. There was no celebration. No moment where I stood in a field with my arms out feeling victorious. That is not how these things work. The land did not change. The cattle did not care. The wheat lease renewed the same as it always had. What changed was smaller than that, and more permanent. I stopped checking my phone every time it rang expecting another letter from a corporation. I stopped wondering if a white truck with a logo on the door was going to come down my drive. I slept better. Not dramatically better. Just the ordinary kind of better that comes when a weight you have been carrying for a long time is finally set down. I told my daughter about the final ruling over the phone. She had known pieces of the story along the way, but not all of it. When I finished, she was quiet for a moment. Then she asked me what I was going to do now. I told her the same thing I did before. Feed cattle. Check fences. Pay taxes. Keep the land running. She laughed a little at that. She said that sounded about right. I also had a conversation with Bert Cassin, the neighbor who had referred me to Dale. Bert had been following the case loosely. When I told him it was finished and we had won on every point, he nodded slowly and said he was not surprised. He said the problem with corporations coming into farm country is that they assume landowners do not understand their own paperwork. I thought that was exactly right. Cresline had sent that first letter expecting one of 2 responses. Either I would not understand the legal language and would simply comply, or I would understand enough to be intimidated by the size of the company and the formality of the claim. Either way, they expected me to move aside. What they did not expect was a metal box with a 36-year-old lease inside it. What they did not expect was an expiration date that had been sitting quietly on page 3 for nearly 2 decades past its trigger point. What they did not expect was a man who read carefully and wrote everything down. I had the county recorder send me a certified copy of the updated property record after the Corporation Commission filing was vacated. I keep it in the metal box now, right next to the original lease. Right next to the manila folder my father labeled in his own handwriting. Someday this land will pass to my daughter. When it does, I will give her the metal box. I will tell her to keep every document, every lease, every letter, every receipt. I will tell her that paper is patient. It waits. And when you need it, it tells the truth in a way that nothing else can. The mineral rights beneath this land are mine. They were mine in 2007 when that lease expired. They were mine when Cresline filed their claim. They were mine when their attorneys stood in that courtroom and could not point to a single line of language supporting their position. They were always mine. It just took a filing cabinet and a careful judge to make sure everyone agreed. I want to talk about what this case actually cost. Not just in money, in time, in energy, in the kind of quiet stress that does not announce itself but sits in the back of everything for months at a time. The legal fees were significant, not ruinous, but significant. There were months where I looked at the invoices and felt the weight of them. I run a working farm. Money is not abstract here. Every dollar that went to the courthouse was a dollar that did not go to equipment maintenance or feed or the water line I kept putting off fixing. The time cost was harder to measure. There were evenings I spent reading legal documents instead of doing the 100 other things a farm requires. There were phone calls with Dale that ran long and left me sitting at the kitchen table after dark trying to organize my thoughts. There were weeks where the case sat in the back of my mind like a low noise I could not turn off. I am not saying this to complain. I am saying it because I want anyone watching this to understand something clearly. Fighting back has a cost. It is a real cost. And you have to decide before you start whether you are willing to pay it. For me, the decision was simple. Not easy, simple. The land is not replaceable. The mineral rights beneath it are not a financial abstraction. They are part of what my grandfather bought in 1951. They are part of what my father maintained for 40 years. Surrendering them to a corporation that had no legal right to them was not something I was willing to do at any price. That clarity made the cost bearable. But I also want to say something about luck, because luck was part of this. I was lucky that my father kept that original lease. I was lucky that the expiration language was clean and unambiguous. I was lucky that the assignment notification clause required certified mail, which gave us a concrete standard to hold Crestline to. I was lucky that Judge Nesmith was methodical and not impressed by industry custom arguments. A different set of facts could have produced a different outcome. I know landowners who have faced similar situations and lost, not because they were wrong, but because the paperwork was missing, or the lease language was vague, or they could not afford to sustain a legal fight long enough to reach a ruling. Those outcomes are real. They happen, and they are not always the landowner's fault. What I can control is what I did. I kept the documents. I read carefully. I hired a good attorney. I did not panic. I did not settle for less than what was legally mine. I documented everything from the first day to the last. That is the part I can pass on. Not a guarantee, just an approach. A way of moving through a fight like this with your head clear and your paper trail intact. It is not dramatic. It does not make for a loud story, but it works. There is one more thing I want to address before I close this out. After the appeals ruling was published, it became part of the public court record. Anyone can look it up. A few months later, I received a call from a man in Kingfisher County. He had found the case through an online legal database. He was facing something similar, a different company, a different lease, but the same basic pattern. A corporation claiming mineral rights through an assignment chain that had problems in it. He asked me what I did, how I started, what I wish I had known. I talked to him for about 40 minutes. I told him everything I have told you in this story. Get the original documents. Read every clause. Check the notification requirements. Find an attorney who knows mineral and land law specifically. Document every interaction from day one. Do not respond to settlement offers without legal counsel. Do not let the size of the other side intimidate you into making a decision before you understand your actual position. He called me back 3 months later. He had hired an attorney. They had found a similar defect in his assignment chain. His case was moving forward. I do not know how it ended for him. We did not stay in touch after that second call. But I think about him sometimes when I am out on the land. I hope his metal box had what he needed, because that is really what all of this comes down to. Not just mineral rights, not just Oklahoma property law, not just one man against one corporation on 480 acres in Garfield County. It comes down to whether ordinary people who own land understand what they own, whether they keep the papers, whether they read the documents carefully enough to know when someone is telling them something that is not true. Corporations that file claims like Crestline did are counting on the opposite. They are counting on landowners who do not have the original lease, who cannot find the expiration date, who do not know what certified mail notification requirements mean, who are overwhelmed by legal language and official letterhead and the implied authority of a company with a floor of a downtown building. That is their business model in cases like this. Remove the information gap and the entire strategy collapses. I am not a lawyer. I am not a legal expert. I am a man who farms 480 acres and keeps a metal box under his desk. But that metal box and what was inside it dismantled a corporate legal claim that had been building for years before I ever received that first letter. The expiration date was always there, on page 3, in plain language. Waiting. My father put it there when he signed that lease in 1987. He did not know what he was building. He was just being careful the way his father had taught him to be careful. 3 generations of careful turned out to be enough. I want to leave you with something practical. Not inspiration, not a speech, just the specific things I did that made a difference in this case. Because if you own land, or if someone in your family owns land, these things matter. First, know what your deed covers. A surface deed and a mineral deed are not always the same thing. In many states, mineral rights can be severed from surface rights and sold separately. Find out what your deed actually conveys. Read it. If you do not understand it, take it to a land attorney and have it explained. Second, if a mineral lease exists on your property, find it. Read the term length. Read the expiration date. Read the renewal clause if there is one. If there is no renewal clause, that is important. Write those dates down somewhere, you will not lose them. Third, check your county property records periodically. In most states, anyone can file a claim or a lien against your property. You will not automatically be notified. Go to your county assessor or recorder's office once a year and ask if anything new has been filed against your property. It takes 30 minutes. It can save you years of trouble. Fourth, if you receive a letter claiming rights to your land or minerals, do not respond without legal counsel, not even a polite letter saying you disagree. Contact a land or mineral rights attorney first. Let them guide your response. Your words in writing can become part of a legal record. Fifth, document everything from the moment a dispute begins. Every phone call, every visit, every letter, every name, every date. A plain notebook works fine. Write it the same day it happens while the details are clear. Sixth, do not let the size of the opposition decide your response. Large companies have large legal teams. That is real. But large legal teams cannot manufacture documents that do not exist. They cannot create a certified mail receipt that was never generated. They cannot make an expiration date disappear from a lease. The facts are the facts regardless of how many attorneys are presenting them. Seventh, keep your original documents, not copies. Originals in a safe place, a metal box, a fireproof safe, a safety deposit box, the original lease, the original deed, the original survey. These documents are the foundation of everything. My grandfather did not have a lawyer when he bought this land. He had $1,100 and a handshake and a piece of paper that said the land was his. He kept that paper. My father kept it after him. I kept it after my father. That piece of paper and everything that came after it is why I am still standing on this land today. Why Crestline is not. Own your land. Know your land. Keep your papers. That is all it takes. That is everything it takes. It is late April now. The wheat on the north fields is coming in green and even. The cattle are settled. The creek on the east boundary is running clear after the spring rains. The land looks the way it has always looked this time of year, quiet and working and indifferent to everything that happened over the past 2 years. I walked the full perimeter of the property last week, all 480 acres. I do it every spring. It takes most of a day. I check the fence lines. I look at the drainage. I note anything that needs attention before summer comes in hard. I have done that walk every year for 31 years. This time felt different. Not dramatic, just different. The way a room feels different after you have cleaned it out completely. The same room, but cleaner. More itself. Somewhere beneath my boots as I walked that perimeter, there is a mineral formation that a corporation once thought they could claim. That formation is still there. I do not know exactly what it is worth. I do not spend much time thinking about it. What matters is that it belongs to this land. And this land belongs to me. Not to a lease assignment chain built on an expired document, not to a corporation with a floor of a downtown building, not to a VP named Marcus Hale, or an attorney named Preston Gage, or a field representative named Todd, who smiled at me like I did not understand my own situation. To me, to Ray Elkins, same as it has always been. I stopped at the southeast corner of the property near the end of that walk. There is an old fence post there that my grandfather set by hand sometime in the early 1950 seconds. It is cedar, still solid, still straight. It has outlasted more things than I can count. I put my hand on it for a moment. I thought about the metal box. About page 3 of a lease signed in 1987. About a certified mail requirement that a corporation assumed no one would ever check. About a judge who asked one quiet question that an attorney with 42 pages of arguments could not answer. I thought about my father labeling that manila folder in his careful handwriting. Then I kept walking. The land was still there. The boundary was still clear. The post was still standing. Some things hold. If you are watching this and you own land or your family owns land, I want you to hear this one last time. Know what you own. Keep what proves it. Read what you sign. And when someone comes with a claim that does not feel right, do not move. Stand still. Pull out the papers. Read carefully. The truth has a way of being on page 3. You just have to look for it.